scheduled for our sentencing hearing today is July the 13th, 2021 again. At this time, I'm going to just put on a record who all we have with us today. State, if you'll go ahead and introduce yourself, please.
Yes, sir. Tom Williams for the state.
And defense.
Ryan Davis for Mr. Wester. Excuse me.
Good afternoon, Your Honor. Michael Offerman, appellate counsel for Mr. Wester.
All right. And we will note that Mr. Wester is here as well today. Good afternoon, sir. All right. The first thing I want to go over is the pre-sentence report that the court got. I believe it's dated June the 22nd, 2021. State, did you receive the PSI in this case?
Yes, Judge.
Defense, did you receive a copy of the PSI in this case?
Yes, Your Honor.
Mr. Davis, have you gone over the PSI with Mr. Wester, and are there any changes or additions the court needs to take into consideration?
Judge, the only thing that I would note for the record in the PSI is that under the incidents, there are several things listed in here that Mr. Wester was found not guilty of. So we'd ask the court to not consider any of that when fashioning a sentence when we get to that point.
Thank you, Mr. Davis. Mr. Williams, anything that you want to say in that regard?
I agree with that position, Judge.
I do as well. All right. Next thing the court wants to address with counsel is the proposed score sheet. State, if you'll take a moment and go over the proposed score sheet indicating the minimum score that it sets forth, and just take your time and go through it and how that number was reached.
Yes, Judge. In section 1 for the primary offense is racketeering, which was count 1. Would you like me to announce these as they reflect the counts and the information?
If you don't mind, sir.
Yes, sir. That relates to count 1 of the information that the jury convicted him of. First degree felony, it's a level 8, which scores 74 points. In section 2, under additional offenses, there are 3 counts of official misconduct, which relate to counts 7, 9, and 10. Information, those are third degree felonies, level 4, scored at 3.6 points each for a total of 10.8 points. Also in section 2 are 3 counts of perjury, which is a misdemeanor. Those relate to counts 19, 21, and 22 of the information that the jury convicted him of. Those are scored at 0.2 points each for a total of 0.6. Next in that same section are the fabricating evidence counts, which there are 3. And those relate to counts 31, 33, and 34 of the information that the jury convicted Mr. Wester of. Those are third degree felonies, level 3, scored at 2.4 points apiece for a total of 7.2 points. On page 4 of the proposed score sheet, section 2 continues under the heading additional offenses. There's possession of controlled substance methamphetamine, which is third degree felony level 3. There were 3 counts relating to counts 41, 44, and 48 of the information. A third degree felony level 3 scored at 2.4 points apiece for a total of 7.2. There was an additional possession of controlled substance marijuana count, which is a misdemeanor. That was count 49, scored at 0.2 points. There was a single one for a total of 0.2. There were 3 possession of drug paraphernalia counts, misdemeanors, scored at 0.2 points for a total of 0.6. Those were counts 54, 57, and 60 of the information. And then there were 2 false imprisonment counts, each a third degree felony level 6, scored at 18 points apiece for a total of 36 points. The defendant has There were no victim injury points under Section 11. There were no prior record points under Section 4. No legal status, community sanction, firearm, or prior serious felony or enhancement points added. This cumulative total was 136.6 points, which is greater than 44. Our formula produced a lowest permissible prison sentence of 81.4 months.
And the court would just let the record reflect that the counts as set forth by the state are the counts as reflected in the May 18th jury verdict that the court filed on May the 19th. Mr. Davis, do you want to put anything on the record with respect to the proposed score sheet in this case?
No, Your Honor.
Understanding the argument that Mr. Wester has as far as the racketeering charge goes on appeal, are the calculations set forth on the verdict form appropriate in this case, Mr. Davis?
Yes, sir. We don't have any, at this time, we have no objection to the score sheet.
State, is there any minimum mandatory sentence the court needs to be aware of today?
No, Judge.
Any other discussion that we need to have, Mr. Williams or Mr. Davis, prior to the court hearing any factors want to be considered from the victims or any mitigating factors today, sir?
No, Judge.
Anything?
No, sir.
All right. Mr. Williams, does the state want to present any sort of testimony today?
Yes, sir. May I inquire of my witness?
Sure, take your time.
Judge, the state calls Teresa Odom.
Okay, Ms. Odom.
Would the court prefer the witness here or at the,
She's fine there, sir, today.
Yes, sir.
Thank you.
I'll just stand close to this microphone.
If you'll point that mic right there at her, that may help pick it up for us. No, the one beside her, that one doesn't work as well. Yes, sir. Just kind of point that at her. That would be wonderful. Thank you. Ma'am, you may proceed.
Thank you for allowing me to be here today, Judge. And to you, Mr. Wester, you've robbed me of my credibility being a mother and a grandmother for the last 3 years. I've probably missed 1.5 years of my grandbaby's life because of this. I wish you no ill will, and you'll never know what you've done to me until you have children of your own. So that's all I have to say.
Thank you, ma'am. Counsel, I do want to note for our record, I think it would be appropriate this time that the court notes that along with the PSI, it did get a letter from Stephen Van dated June the 6th, 2021, as well as Teresa Odom.
Yes, sir.
All right, thank you. Any other presentation for the court's consideration today?
Only argument at the appropriate time.
Okay. Mr. Davis, anybody that you want to present to the court today?
Yes, Your Honor. We have 4 people that would like to address the court on behalf of Mr. Wester.
Yes, sir.
The first one being Michael Montague.
All right, Mr. Montague, come on up, sir.
You want him over at the podium?
That's fine. Yes, sir. Would you like to ask him questions, or do you want me to give him liberality, sir?
Judge, he has a prepared statement
That's
that he
perfect.
just wants to read to the court.
That's
so if you
fine.
could introduce yourself to the court and then read your statement.
Sure, absolutely. I'm Michael Montague. I am a pastor of Mr. Zach Wester.
Can you spell your last name, sir?
Yeah, it's Montague.
Thank you, sir. You can go ahead.
Very welcome. First off, I want to say thank you for this opportunity to speak on behalf of Zach. A few things. There are a few people you meet in life for the first time that you understand it was God sent and life-changing. Many go through life with associates that many label as friends, but few find friends who are genuinely trusted in your life and want nothing more to have success and happiness. Zach was that for me. Every person that I have known, the longevity I've known Zach in, when he's made contact with certain individuals in life, and influenced them, there was one common thread that would always be consistent of. They were better for it because they met him. Proverbs 27:17 says, as a iron sharpens iron, so one person sharpens another. Zach was interested in nothing more than to help me reach my full potential and never let a momentary lapse be my ceiling, but rather my launching point. I remember one moment in my life was dark, depressing, and what seemed to be hopeless. Zach was relentless. See, I was prone in these situations to distance myself and distance from everyone and anyone during these moments, but Zach wouldn't let me. It was our tough conversations and his relentless pursuit. I realized what type of friend Zach would be for me. Zach did not love partially, but rather he loved with his whole heart. He gives it away, and he did not mind it being trampled on. He didn't say much when it was. In the few years that I've known Zach, there was one thing I realized. We need more men to have a heart like him to bring healthy change in our communities. One who would give their heart away to a person that others may overlook. When a person calls at the most inconvenient times, one that will put everything down and would go simply to serve you. When you're at the brink of giving up, his relentless pursuit to fight for you when you didn't feel like fighting for yourself. This is not only what he did for me, but this was how he did for many others countless times before. There are so many people we can never become until some people come into our lives. Zach is an asset to everyone's life, not a liability. He didn't withdraw from people emotionally. He didn't leave them depleted when he left their presence. In fact, he deposited hope in their lives, inspiration, motivation, and encouragement. Zach didn't just give you company, he gave you connection. He gave you vitality. He gave you honesty. He gave you his ability to look at you in the eyes and say, I know you more, but I don't love you less. I remember the story of a young man being thrown into jail by his brothers for nothing more than being loved by his father and having a dream. At that moment, his life would have seemed to be at a downward trajectory, as the reader would assume. His brothers threw him into slavery. A group of people called the Ishmaelites took him to Egypt, sold him to Potiphar, the captain of administrative of Egypt. It was there the Potiphar's wife looked at him and called him to be a rapist. He predicted in that moment when he was thrown into a jail cell, he was predicted that Egypt would go into famine for 7 years, and he prepared for it. When the time came, surrounding regions were dependent on Egypt for food, including the very brothers that threw him into jail. Joseph's brothers journeyed to Egypt for food, but rather what they found was the very brother they threw into slavery. Well, all the power that Joseph had in this moment, he had all the power, he had all the right to execute a swift judgment and swift justice to the very ones that threw him into slavery. But he did something that was far more transcending. He looked at them in the eyes and he gave them mercy. And because he gave them mercy, it was the very tool that the brothers had the ability to bridge family back together. For he went back to his father and he told them, I have found our brother. I have found your son. And it reconciled family again. Judge, my request today is that you would consider giving mercy and grace to a husband, son, and friend. There's a common theme that I hope that we all can hear about Zach. He's not a liability to society, but rather he's an asset. Allow him to help once again change lives and bring hope to community. Thank you, sir.
Thank you. All right, who would you like to call next?
Brandon McDonald.
Good afternoon, Your Honor.
Afternoon.
First, would like to thank you again, like Mike did, for allowing me to speak on Zach's behalf today. I do know the weight of the decisions that are on your shoulder are very heavy, and I do thank you for your fairness before, now, and in the days to come. Today, I ask for two things, mercy and compassion, which are a sign of true justice. Zach has been a stronghold in my life. I met Zach in a time when I needed him the most. He has been the missing piece in our lives to which nothing has been able to fill since his departure. He is one of my two truest friends. His heart to serve others has been a catalyst in my life to show me how to be a better person myself by watching him care for others, talk with others, be a shoulder to cry on, and to be a rock in not only my life, but in the lives of many others. I've watched this man, when I called him after a car hit our family dog, leave his house in the middle of the night to help us bury our dog and stay until we were finished. This may seem insignificant to some, but it was a moment and one of the many examples that showed his true willingness to help others and be there whenever needed. It also helped further my trust in our brotherhood and friendship. I've seen him work long hours to provide for his family in the hot hours of the day and even night. This too may seem strange to some, but this goes to show he is willing to do what is needed to provide for his family. He has also employed those that were in need of a hand up, which shows that he does put others before himself in order to see them succeed. He serves alongside of me at Authentic Life Church. He is the leader, along with his wife, of the pastoral care ministry, in which the sole mission of this ministry is to care for those that need it most, whether it be families which have lost loved ones or to ease the transition of a new life which has just come into this world. In all of these endeavors, he leads others in integrity, honor, respect, and loyalty, always creating a way for them to further their success, ministry, and even personal growth. He is a faithful part of my own family. I never saw myself being the type of person to be a best friend to a guy, but just a guy that has friends. However, through his amazing character, trustworthiness, faithfulness, and adherence to the many issues my family has faced, he was able to break a wall that I've never allowed to be broken. Zach, or Zach, or Mike, as my little one likes to call him, or rather scream at him when he sees him, has been a godsend into our lives. Many people do not know this, but when I met Zach, I was in a place of hurt and did not know what it meant to have a brother. As I am an only child, I have other siblings by marriage, but I do not carry a deep relationship with them. So to know what a brother was or even felt like, I did not know until I met Zach. As mentioned, he is a godparent to our little ones, Elias, David, and Ezra Leon. He is their caretaker when we are not able to do so, and he loves them with the same integrity, respect, honor, and loyalty that he shows everyone else. I know without a shadow of a doubt, I can trust him with my own kids, and I will, and I would do so if the situation ever arose. In conclusion, Your Honor, Zachary Tyler Wester is a man of honor. He's a man of respect. He's a man of integrity, and most importantly, a man of loyalty. He stands on faith of the many promises bestowed upon him and his family, despite the many adversities that he's faced in his family, in his career, and even personally. I reserve him as one of the few people in my life I can firmly say with no doubt in my mind he is and will always be a man of great character. And as I stated before, I know you face a tough decision and the weight of this is on your shoulders. I ask you for leniency with any sentencing that has to be done. My reason for this is because of the hole that is left when Zach is not in our community, when he's not in our lives, because he is such a vital part in our family. He is a rock and he's a tremendous helper, not only in my own personal life, but he's my friend, my brother, and my closest ally. Supreme Court Justice Charles Evan Hughes said this: "A man has to live with himself, and he should see to it that he always has good company." In Your Honor, Zachary Tyler Wester is good company. Thank you again for your time, your considerations, your mercy, compassion, and leniency. Blessings.
Thank you, Mr. McDonald.
Thank you.
Who do you want to call next, sir?
Jerry Johnson.
All right, Mr. Johnson.
Good afternoon, Your Honor.
Afternoon, sir.
My name is Jerry Johnson. I've had the privilege to walk life with my friend and brother, Zach Wester, for the past several years. I appreciate the opportunity to share with the court today and offer a small glimpse into each of our lives and hope that you may strongly consider some vital points in the sentencing for Zach and the impact it will have. Zach has been a friend to me, encouraged me when I needed to be encouraged, and he's challenged me when he saw something in me that needed to be challenged. and we've sat in circles together as iron sharpens irons. He's been a listening ear on more than one occasion, some of which have been in dark and hard times in my own life. There are things we go through or experiences in life that we can't share with just anyone. But Zach has been a trusted friend, even in the times when he faced uncertainty himself. Not only is he a true friend to me, but he's a true friend to others. I watched him do much of the same things for other men, such as being a listening ear, providing encouragement and faith, and even throwing in a joke now and again to bring light into a dark time and shift the environment to one of hope. I truly believe that Zach is such a good friend to others because he knows what it's like to need a friend. I've had the opportunity to serve with Zach in several different ministries. Most of that time has been spent in our home church. We're a modest-sized church, but growing church in a community much like this one. We're a small hometown feel. My wife and I serve in leadership with Zach and his wife. The heartbeat of our church extends outside the walls to make a difference in the lives of those who need it the most. It takes us all working together and each doing our part to make the impact that we do. Zach is a very important instrument and a part of that team. As our pastoral care team, Zach is responsible for meeting the physical needs of those within our church and community. As group leaders, we depend on them, and they are available anytime, day or night, when one of the young people from our groups has a need, such as food, clothing, financial assistance, or any other vital daily life necessity. The pastoral care team is vital to us as leaders because they are the hands and feet that go and take and help share the workload of our entire leadership ministry and provide this type of support for all our different ministry areas and groups. Zach has never hesitated to serve wherever he is needed, whenever he is needed, and by whomever is needed. In addition to being the pastoral care leaders, we've served side by side at ministry projects to bring up young men to become the men of God they're called to be and provide food distribution to several hundred families in one day on multiple occasions. They've prepared, cooked, and served meals to grieving families during times of loss and stayed in contact with those families to make sure all needs were met. Unless you have the opportunity to walk life with someone, you truly don't understand just how much they give and do for others, and much of that goes unnoticed. As both a public safety professional, a youth and young adult leader, I feel as I have a unique perspective of the devastating impact the lack of male leaders and role models has on a community such as our own. I believe that the strength and health of a community is built upon a foundation of having strong men willing to stand up and invest in other young men, leading and guiding them to make responsible decisions. We've watched the Westers as they've encouraged, prayed for, and helped invest in the lives of other young people. Removing Zach from our community removes his influence over young people who may not have someone else to invest in them. Someone who cares about their future and helps guide them into their potential. Someone who will be there for them when everyone else has turned their back. Someone who will simply be a listening ear to one who feels lost and hopeless. Zach isn't just a good man, but he's also a leader of leaders. He's the person that invests in and equips in others to do good works. The one who's encouraging others to step up and outside of their own comfort zones, to challenge themselves and to be what God's called them to be. He's the one who says and believes you can when others are saying you won't and you shouldn't. He's the one who keeps our leaders' meetings fun, and he also helps me pick on our pastor and keep him on his toes. But at the end of the day, his heart for those who are hurting is what speaks to me the most. We don't choose these professions because of pay, the attention, or even the power, as some believe. We choose these professions because we believe it takes one to make a difference in the life of another person, and we are called to be that one. We choose them because we want to help others, and we want to invest in the places that we live. And even if Zach's time in public safety is over, I believe he'll always continue to invest because that's the man he is. I've known Zach to be a hardworking man who has started to work and build and maintain a successful lawn business. His business not only is provided for his own family, but it's also provided for the families of those he's employed. Maintaining a successful business requires that you be present and model the work ethic that you expect from your employees by working by their side to earn their trust and respect. Throughout this process, Zach has experienced consequences that I'm requesting the court to consider in determining sentencing. The time and effort to get and maintain certifications, the continual education that is required to keep up with the changes in public safety professions, the loss of all that time and credentials, the loss of retirement, time vested, the loss of his reputation, trust and respect of his peers and those within this community, the need to relocate his family for several reasons, and a host of other consequences that I don't feel we need to burden the court with. We respect the judicial system of our nation and the nations made by this court. I'm sincerely asking that you consider not just the punishment that Zach has already experienced, but also the devastating impact of removing him from the people and ultimately the community that he invests in and those that invest in him. I believe there are consequences that should be reserved for those who are a threat or a danger to community, or those who refuse to become productive members of society. I also believe there are consequences reserved for those who would be most beneficial by being in their communities, serving and investing in others, by sharing their experiences in the hopes of changing the lives of another. Not giving Zach the opportunity to continue serving means taking someone out of the community who is already making a difference in the lives of others. I sincerely appreciate the privilege to be here today and plead for mercy in sentencing on behalf of my brother and fellow servant, Zach Wester. My prayer today is that this court sees how much Zach is needed in his home, in his church, and in his community. Thank you, Your Honor.
Thank you, Mr. Johnson. Mr. Davis?
It's Rebecca Wester.
Good afternoon, Ms. Wester.
Good afternoon. Thank you.
Ms. Wester, you're Zachary Wester's wife?
Yes, I'm Zachary Wester's wife.
Which county are you currently residing in?
Wakulla. Your Honor, I am here on behalf of my husband, Zachary Wester, who is appearing before you today for sentencing. From the moment I met Zach, as he walked into my office, his charm, his laughter, and the love for others around him was instantly realized. The day I met Zach Wester was a day I will always remember, because for the next 11 years, he has been part of my story. As newlyweds, Zach worked a job during the day while attending the law enforcement academy at night, always determined to provide for his family, even while pursuing his dream career. From a young age, I hear stories that Zach, all he wanted to do was serve his community. 6 months before we got married, my mom passed, and I experienced firsthand the love, the compassion, and the servant's heart that is exemplified in Zach. Your Honor, I have seen the long hours, the tireless shifts, the tears that were shed, the missed holidays, and the love for Jackson County that my husband displayed throughout his law enforcement career right here in this county. When that career ended suddenly, I watched a part of him and myself as well die. This blow was not one that will be overcome quickly, and in all honesty, I think it will forever be a burden that my husband and I will carry. But I want to say that I could not be prouder of this man sitting here. He has grown into a man in the last 3 years when a portion of his life ended, and he could have ended as well. In the time after the allegations were brought against him, he moved our family and life that we had created here in Jackson County to my hometown in Wakulla after Hurricane Michael wrecked our home. Faced with the allegations, finding any type of employment was nearly impossible, but Zach was determined. He was determined to regain a sense of normalcy in our lives. Zach worked odd jobs to help provide for his family during this time. He was determined to make a life for himself that suddenly didn't involve law enforcement. So we decided that we would start our own company. When we made the decision 2 years ago to start our landscape business, I saw a side of Zachary that I had never seen before. The entrepreneur, the servant, but in a different capacity. He worked to build the business from the ground up to not only provide for me, but to regain what he could of his reputation, gaining the trust of his customers and offering excellent service, which led to more recommendations. He took every opportunity to grow our business and serve those that entrusted their business to him. The level of dedication to this business was evident as he worked until the day before the trial started, and even on the weekend between the 2 weeks, to ensure that his customers were going to be taken care of. Sir, the Zach that is in the court before you today is also a mighty man of God, as you have heard. He is a mentor to many young men in our church and community. Another piece of evidence to show his servant's heart. Authentic Life Church has embraced our family, and we truly feel that this is where we belong, serving and loving those in our community. Zach was chosen this year to start an internship to train in becoming a pastor within ALC. And we both currently serve as leaders in the church. We are over the pastoral care ministry. This ministry has allowed me to work alongside my husband to provide food, groceries, utility assistance, and bereavement services, sometimes from our own pocket, to members in our church and the community. I have watched as Zach has prayed with families that just lost a loved one or drop everything and rush in the middle of the night to help when someone is in need. He makes every decision in his business, his family, his personal life by first seeking the Lord's wisdom. Watching him step into this new calling of a teacher and mentor and pastor has been one of the most exciting and proud times for me as a wife. He has reached many hearts with his testimony and the true love of God he displays in his everyday life and his sermons. Zachary, as a member of our community, church, and society, has greatly been missed these last weeks. But the place he has been missed the most is in our home. The home that we worked so hard to purchase this past August, even during this time of uncertainty. They say that little things are what you miss the most when someone's not there. And these last weeks have proven that to be the truth. Our home is much quieter and not so much laughter and gatherings, but the memories that we have made and we still have left to make are all around. But most importantly, his absence does not allow him to continue to take care and serve the most important thing in his life, me. Not only is he missing in our home, but also the homes of our friends. I have watched as he has made friendships that have become family. Some of these friends, or more so brothers, you've already heard from today. And I can truly say that we have found our village. Though we have no children of our own yet, I can without a doubt say that his servant's heart will one day be fulfilled as a father. I know this because never have I seen a man love two children that are not his own the way that Zachary loves his godchildren. Elias, who is 2, and Ezra, who's 2 months, have grown very attached to him, and Zach is truly missed and asked about every day. I understand the weight of the decision that you have to make before you. And as you have been fair throughout this entire trial process, I have no doubt that you will take into consideration the person Zachary is and his contribution not only to this community, but to his friends, family, and myself. There's a verse in the Bible that reminds me of the dedication that Zach exemplifies in everything he does. Isaiah 6:8 says, "Then I heard the voice of the Lord saying, 'Whom shall I send and who will go for us?' And I said, 'Here I am, send me.'" This is a verse that embodies Zach in whatever aspect in life he's been called to, whether that be his job, his church, his community, or his family. His answer has and always will be, "Here I am, send me." Thank you.
Thank you, ma'am. Anybody else, Mr. Davis, on behalf of Mr. Wester?
No, sir.
Does Mr. Wester care to address the court today, sir?
No, Your Honor.
Any further argument or mitigating factors to be presented from the defense?
Judge, I just have some brief argument if you want to hear from me now.
I'll let the state go, and then the defense, you can respond. Go ahead, Mr. Williams, if you're prepared to give argument.
Yes, sir. Would you like this, would you like separate arguments for the appellate bond issue?
Appellate bond will be next, sir.
Okay.
Yes, sir.
Okay. Judge, I know the court and the defense are aware, but for record purposes, I would note that Florida Rule of Criminal Procedure 3.701 addresses the sentencing guidelines under subparagraph 2 and 3. I would like to read in the record at this time that the primary purpose of sentencing in Florida is to punish the offender. That rehabilitation and other traditional considerations continue to be desired goals of the criminal justice system, but must assume a subordinate role. I believe that's particularly relevant given some of the testimony from church members here today. Subparagraph 3, the penalty imposed should be commensurate with the severity of the convicted offense and the circumstances surrounding the offense. That's something that I'll address as well when we go on to the appellate bond issue. But Judge, I have a hopefully a brief statement, prepared statement that I'd like to read to the court. The jury, of course, as this court knows, convicted the defendant of crimes committed against 3 members of this community. Mrs. Odom, who is here today, Mr. Van, who was not comfortable being here today, but did write a letter. It's a part of the record, and Mr. Emmanuel. The evidence at trial demonstrated that the defendant planted methamphetamine or paraphernalia in each of these victims' cars under the guise of performing a lawful roadside search of their cars. He then falsified arrest reports and submitted them to the sheriff's office. These false records were later relied on in this very courthouse to prosecute these innocent victims for crimes they did not commit. And at the time of his suspension from the sheriff's office, he had a stash of more methamphetamine and more paraphernalia hidden in his patrol car for that very use. Now, Judge, the defendant's criminal conduct represents an egregious breach of the public trust. The state's first exhibit in this case was his identification card from the Jackson County Sheriff's Office. And I read an opening statement and in the record at trial, the oath that he swore to hold that badge and that ID card. And in democratic free societies, people voluntarily grant their government awesome powers that they deem necessary for public safety and protection. And with that power, we've all heard this said before, with that great power comes great responsibility. The defendant made choices to violate that trust and commit crimes against the very citizens that he had sworn to protect. That's what he was convicted for, violating that trust to commit crimes against them, to victimize them. His actions thus attack the very foundation of the criminal justice system that we enjoy in these free democratic societies. His punishment should reflect that. Those are the surrounding circumstances. The state is recommending 15 years in state prison. We're also asking that restitution be ordered. I would ask simply for 30 days for the court, for the state to provide an amount to the court and the defense to determine what specific amounts may be owed to the victims for the cost of expungement of their falsified criminal records. But Judge, we believe in relation to the rule that I've cited previously and these surrounding circumstances and the effect that that has in a society and its trust in law enforcement, that the score sheet is not enough. The score sheet does not take into account the surrounding circumstances. And that's why that rule of procedure is there. And that's why I'm asking this court to consider a sentence of 15 years. Thank you, Judge.
Mr. Davis.
Good afternoon, Your Honor.
Afternoon.
Judge, this sentencing is a little different for me. In most cases, I am here arguing downward departures, asking for a below the guideline sentence. We're not doing that today. We are not going to ask you to go below the guidelines. Mr. Wester is here today, and he knows that he's going to be sentenced to prison today. It's just a matter of how much time is he going to be sentenced to prison. The legislature has codified how we come up with this based on what Mr. Wester was convicted of by the jury. I believe it was 19 counts out of the 67 that were originally charged in this case. The bottom of the guidelines, as we often refer to them in this case, is 84.1 months. Other things to consider are the people that are here for him, the effect, the good effect that he's had on many in the community that he has been in for the last several years since this case has been pending. Also, he is a former law enforcement, and any time that you sentence him to is probably going to be harder than most time that you've sentenced other people to. Since we've left here back on May 18th, I believe was the day of the jury verdict, Mr. Wester has been locked up for at least 23 hours a day and has only seen the outside a couple of times. I believe there's two reasons for sentencing. One is specific deterrence and general deterrence. Specifically, Mr. Wester is going to go to prison and he's going to serve time for this. Whenever his sentence expires, the sentence, whatever sentence you sentence him to, when it expires, it's not going to be the end for Mr. Wester. In this day and age of the internet, YouTube, Facebook, Twitter, you type in Zachary W and you're going to get Wester and you're going to get all of these videos and all these things about him. His name is always going to be synonymous with a bad cop. In spite of that, and despite what has been out there for the last several years, he has been able to establish a new life, establish himself, and do good for his community. He has a lot of people here, and you've received many, many letters from others that couldn't be here. When we were told that there was only going to be 12 spots for people to sit in the audience, those 12 spots were snapped up like that. We could have filled the courthouse with people that would have been here on behalf of Mr. Wester.
And I will put on the record that I got significantly a greater volume than 12 of letters. So I've got a majority of this notebook full of letters.
Yes, sir. But Mr. Wester has shown that he can still contribute to society and be a productive member of society. As to general deterrence, I think that's also been accomplished already. Other law enforcement officers have seen Mr. Wester placed on leave, then fired, then arrested, convicted, and today they're going to see him sent to prison. He will never be a law enforcement officer again, but he will continue to be and will always be a husband, a son, and a friend to those that know him. Judge, we're asking you to consider also that he does have no prior record, which I think is something that is very important in this case, that he has done good and he will continue to do good. And we're asking the court to consider a sentence at the bottom of the guidelines of the 81.4 months in prison. Thank you.
All right, I'm going to go ahead and hear argument at this time. The court has also gotten in its possession a motion for post-trial release that I'm going to go ahead and hear argument for. This motion was filed July the 7th, 2021. Counsel, are you ready to proceed with your motion, sir?
Yes, Your Honor.
You may go ahead.
Thank you. May it please the court.
Yes, sir.
Michael Effner on behalf of Mr. Wester. Your Honor, I won't belabor the standard for bail pending appeal. I know the court is familiar with that. In his appellate practice treatise, former Judge Padovano really sums up the standard as twofold. One, is the defendant a flight risk such that if after the appeal is over, if the appellate court affirms the convictions, affirms the sentence, will he show up to serve his sentence? That's the first factor, Your Honor. And the second factor is there a fairly debatable issue that's going to be presented on appeal? Regarding the first factor, Your Honor, I think the record's clear that my client has ties to the Panhandle. He previously had ties to Jackson County, but as a result of this case, obviously he moved one county over. But you've heard today from members of his church. You've heard from his wife who lives in Crawfordville. His mother and father are here who live in Sneeds. He clearly has many family ties in this local area such that he's not a risk that should the appellate court affirm his sentence, that he won't serve out that sentence. He knew prior to trial, in this case, went on for a while, Your Honor. He was on pretrial release. He showed up at all court proceedings. He showed up for trial at a time when he was facing far more charges than what he's now been convicted of. I submit to you that in light of what you heard about his involvement in the church, that should the appellate court affirm, he will be there to turn himself in at the appropriate time and serve his sentence. So I submit we meet that first factor. The second factor I submit we also meet, and I think this one's just as clear, Your Honor. I've cited in my motion, and I'll repeat it. The standard is, has the defendant presented a fairly debatable issue? I've cited from the Childers case, which in turn was quoting from the Baker case from the 4th DCA. Childers is from the 1st DCA. I'll quote, "Good faith does not mean that there is probable cause to believe the judgment will be reversed, but simply that the appeal is not vexatious and the defendant has assigned errors that are open to debate and about which reasonable questions exist." Your Honor, I'm not going to re-argue the motion. And you've heard it several times. I know Mr. Davis has brought it up during the trial. He brought it up again shortly after the trial. The court, I believe, has struggled with this issue. I think it's been an issue that the media has talked about from day one in this case. You've obviously ruled the way that you ruled. I'm not here to try to convince you to rule a different way, although I will try to do that on appeal with the appellate court. But that's not the standard, and I know you wouldn't consider that to be the standard. In Childers, the 1st DCA said that post-trial release is not dependent on whether the appellate issues have been raised before the trial court and rejected. The standard is whether the issues raised are open to debate and involve reasonable questions. After all, most issues raised on appeal have been presented to the trial court and rejected. Clearly, this issue regarding racketeering and whether or not, in this case, the state has met its burden of showing that the sheriff's office was the enterprise for purposes of the racketeering statute. That's a debatable issue. I've heard one judge, when I've made these arguments in the past, refer to the standard as, if the public defender's office got this appeal, if my client was deemed indigent, would they file an Anders brief? Or would they brief this issue? I think clearly this issue is going to be briefed. It should be briefed. It's a reasonable issue that's open to debate. And should he be successful on that, I know there's other arguments that flow from that. The other charges involving the various alleged victims in this case were brought together because of that single racketeering count. Had the racketeering judgment of acquittal been granted, I think Mr. Davis's next move would have been to file a motion for mistrial on the other counts because they were improperly consolidated as a result of the racketeering count. So I think the appellate issue, and obviously I'm going to review the record from cover to cover, and there may be others, but that's clearly the issue I think that's been the focus throughout the trial, and I think it covers not only the racketeering count, which is the most important count for which my client is being sentenced, but also it extends to the other counts as well. So I would ask this court to grant a reasonable supersedious bond. I submit to you that my client will show up if the appellate court affirms. There are conditions I believe you can put in place to make sure that he remains in his community, although again, I don't believe that he's a flight risk. I think he clearly has substantial ties to the community, and we believe he meets the standard, and we'd ask you to grant the motion, Your Honor.
Thank you, sir.
Thank you.
Mr. Williams, any other argument before, well, first of all, you want to respond to that motion?
Yes, Judge.
Go ahead.
Judge, regarding my response first is in regards to some of the factors that the court is to consider for this type of motion under Youngins v. State. The first factor, the habits of the individual as to respect for the law, clearly has no prior criminal record. I'm not trying to imply anything otherwise. He does not. He seems to have an exemplary prior personal record. However, I will say, and I would ask the court to consider his crimes that he's been convicted of and the pattern of conduct that demonstrates over that period of time when considering the habits of the individual as to respect for the law, in that he was a law enforcement officer. I would also ask this court to consider that the defendant, 3 of his charges were for official misconduct and providing falsified records that ultimately relied on in this very courthouse. I do not believe that should be overlooked. regarding the third factor, the severity of punishment, of course, Mr. Offerman, Mr. Davis, and I don't know what that is. We do know that they're not seeking a downward departure, and we do know that it's over 80 months in state prison as the lowest permissible. And we do know that that's what someone who has no prior criminal history and since his conviction at trial had never spent a day in jail. So we do know that that is a particularly severe punishment that he is looking at. That is my argument in response to those factors that the rule would direct this court. And I would also remind this court, as this court's aware, this is discretionary. This is discretionary with this court. It is not something that he has the same right that he would pre-trial, pre-conviction. That's all, Judge.
Any other argument with respect to the motion that's pending?
Your Honor, may I have to briefly respond just to the sentencing argument?
Your Honor, I appreciate the state's argument. I would respond by briefly noting that I think the factors in Youngins all relate to, is there a flight risk or will he show up at the end of the appeal? And for all the reasons I've already said, I believe the record establishes that he would, in light of the fact that he was on pretrial release, he was facing more charges pretrial, and he does have such strong attachments to the community. The quick response I want to make regarding the sentence, Your Honor, I have a case and I have a copy that I'll provide to the court. Thank you. Your Honor, this case is Baptiste. It's BAPTISTE versus State of Florida. It's a 4th District Court of Appeal case from 2013, 134 Southern 3rd, 1025. And in Baptiste, the court referenced a previous case from the 2nd DCA called Cooley. In Cooley, the defendant was facing a minimum mandatory sentence for use of a firearm. It doesn't specify, but I have to believe under 1020 life that the defendant in that case was at least looking at a 10-year sentence and potentially more. In the Baptiste case, the defendant was looking at a 5-year sentence. And the court said that although that's a factor the court can consider, the 5-year sentence in and of itself does not, and I apologize, this is in head note 4. It's about on page 2 of the opinion, the 3rd full paragraph on the right, the court says that a lengthy 5-year prison sentence is not conclusive of whether or not the defendant presents a flight risk. I appreciate that the state's asking for a 15-year sentence. Of course, the court can reject that and go above that, but assuming we're looking at some range in between the minimum on the score sheet and 15 years that the state is asking for, I would submit to the court that that's a standard sentence that would be imposed for a DUI manslaughter case, a second-degree felony, any number of other cases that are similar to that. Courts across the state routinely grant these types of motions for second-degree felony type cases. When you look at the statute that precludes bond pending appeal, it's 903.133, and they list certain first-degree felonies such as arson and kidnapping that the legislature has said the court can't even give bond pending appeal when it's that type of case. I think that gives an indication to the court as what the legislature was thinking at the high end. Someone who's looking at a 30-year sentence for a first-degree felony, that person's ineligible for bail. That type of sentence would present a substantial flight risk. But when we're looking at the range that we're talking about in this case, Your Honor, I submit, given all the factors, that my client satisfies the first Youngins factor and he's not a real flight risk. Thank you.
Thank you, sir. All right. Any other argument want to be presented by counsel before we proceed towards sentencing? Mr. Williams?
No, not from the state.
Mr. Davis?
No, Your Honor.
All right. I'm going to go ahead and put on the record the things that the court has reviewed in its sentencing today. The court has considered the allegations as contained in the most recent information in this case. The court has considered, obviously, the verdict of a jury in Jackson County that occurred in May of 2021, where it found Mr. Wester guilty of the following: Count 1, racketeering, a first-degree felony. Count 7, official misconduct, a third-degree felony. Count 9, official misconduct, a third-degree felony. Count 10, official misconduct, a third-degree felony. Count 31, fabricating of evidence, a third-degree felony. Count 33, fabricating evidence, a third-degree felony. Count 34, fabricating evidence, a third-degree felony. Count 41, possession of a controlled substance, a third-degree felony. Count 44, possession of a controlled substance, a third-degree felony. Count 48, possession of a controlled substance, a third-degree felony. Count 64, false imprisonment, a third-degree felony. Count 65, false imprisonment, a third-degree felony. As well as count 19, perjury, a first-degree misdemeanor. Count 21, perjury, a first-degree misdemeanor. Count 22, perjury, a first-degree misdemeanor. Count 49, possession of a controlled substance, a first-degree misdemeanor. Count 54, possession of paraphernalia, a first-degree misdemeanor. Count 57, possession of paraphernalia, first-degree misdemeanor. And count 60, possession of paraphernalia, first-degree misdemeanor. The court has considered the mitigating factors as presented in the PSI. The court has considered the pre-sentence investigation. The court has considered the letters that were provided to it on behalf of Mr. Wester. And I will just note that there is dozens, I would say close to 50 letters the court has considered on behalf of Mr. Wester. The court has considered the 4 individuals that spoke on Mr. Wester's behalf today. The court has considered Mr. Wester's prior work history. The court has considered the statements of the victims as were set forth today and is set forth in the attached pre-sentence investigation. The court has considered all of those things when determining what a proper sentence should be in this case. And the court has heard the argument of the state that they are requesting 15 years in the Department of Corrections, and the argument of the defense that they are requesting something closer to the 81.5 months that is set forth in the score sheet. Court, I guess it has some flexibility under Florida law to go under, but it's a tough hurdle or a tough thread to bear to get under that score sheet. But the court also has discretion in this case to go above what's recommended by the state. And so that needs to be put on the record today. The court has liberality in that regard. At this time, I'm going to go ahead and adjudicate Mr. Wester guilty. I am going to go ahead and give Mr. Wester 58 days jail credit in this case. There are court costs and fines of $1,065. And I'm going to go ahead, Mr. Wester, if you'll step up, I'm going to get you fingerprinted at this time, sir. Thank you, sir. All right, Mr. Wester, this court now sentences you as follows in this case. As to count 1, racketeering, which is a first-degree felony, you are sentenced to serve 5 years in the Florida Department of Corrections. As to count 7, official misconduct, as a third-degree felony, you are sentenced to serve 18 months in the Florida Department of Corrections. that will be served concurrent with count 1. As to count 9, official misconduct, a third-degree felony, you are sentenced to serve 18 months in the Florida Department of Corrections. That is consecutive to count 7. As to count 10, official misconduct, that is a third-degree felony. You are sentenced to serve 18 months in the Florida Department of Corrections. That is consecutive to count 9. As to count 31, fabricating evidence, that is a third-degree felony. You are to serve 1 year and 1 day in the Department of Corrections, consecutive to count 10. With respect to, as to count 33, that's fabricating evidence, that's a third-degree felony. You are sentenced to serve 1 year and 1 day in the Department of Corrections. That will run consecutive to count 31. As to count 34, that's fabricating evidence. That's a third-degree felony. You are sentenced to serve 1 year and 1 day in the Department of Corrections. That is consecutive to count 33. As to count 41, possession of a controlled substance, that's a third-degree felony. You are sentenced to serve 1 year and 1 day in the Department of Corrections. That is consecutive to count 34. As to count 44, that's possession of a controlled substance. That's a third-degree felony. You are sentenced to serve 1 year and 1 day in the Department of Corrections, consecutive to count 41. As to count 48, possession of a controlled substance. That is a third-degree felony. You are sentenced to serve 1 year and 1 day in the Florida Department of Corrections. That is consecutive to count 44. With respect to as to count 64, that's false imprisonment. That's a third-degree felony. You were sentenced to serve 1 year and 1 day in the Florida Department of Corrections, consecutive to count 48. As to count 65, false imprisonment, that's a third-degree felony. You were sentenced to serve 1 year and 1 day in the Florida Department of Corrections, consecutive to count 64. Counts 7, 9, 10, 31, 33, 34, 41, 44, 48, 64, and 65 are to be served consecutive to each other for a total sentence in this case of 12 years, 6 months, and 8 days in the Florida Department of Corrections. This sentence of 12 years, 6 months, and 8 days in the Florida Department of Corrections is to run concurrent with a 5-year Department of Corrections sentence in count 1. Therefore, it is the intention of the court that you are sentenced to serve a total of 12 years, 6 months, and 8 days in the Florida Department of Corrections. I'm also going to award the defendant 58 days jail credit as to count 1 and count 7. As count 7 is the first sentence served by the defendant in a series of consecutive sentences. Finally, as to the remaining misdemeanor charges, you were sentenced to serve 58 days in the county jail with credit for 58 days as to the following counts. That would be count 19, perjury, count 21, perjury, count 22, perjury. Those are all first-degree misdemeanors, as well as count 49, possession of a controlled substance, a first-degree misdemeanor, count 54, possession of drug paraphernalia, a first-degree misdemeanor, count 57, possession of drug paraphernalia, first-degree misdemeanor, and count 60, possession of drug paraphernalia, a first-degree misdemeanor. Again, it is the intention to the court that you were sentenced to time served on each of those misdemeanor counts. Those, again, are 19, 21, 22, 49, 54, 57, and 60. With respect to Mr. Wester's motion for post-trial release, I have reviewed Rule 3.691. I've also reviewed the law in the Youngshins case, that's 90 Southern 2nd 308. I've also taken into account the argument of counsel for Mr. Wester. I've looked at his community history. I've heard the factors as set forth by the witnesses today, and his work history in this community, his lack of criminal history. I've considered his family ties, himself and his entire family, to this area of Jackson County, Florida, the length that he has been here. I have I've also considered the probability of Mr. Wester appearing for any future hearings I would note that Mr. Wester did attend all of the hearings he was required to be here for, and never fled this court's oversight prior to trial in this case. I would note that this court has also noted that the sentence that's been handed out by the court today is substantial, and that sentence is to be considered by the court in considering Mr. Wester's likelihood of reappearance. Despite the substantial nature of the sentence, I don't think that Mr. Wester at this time that prong of files necessarily in favor of the state, because I can't make a finding that Mr. Wester is a flight risk at this time. So I've reviewed all those factors that have been set forth not only in the rule but case law and the argument of counsel. I will also note that the court did consider, when it looks at the behavior of Mr. Wester, I do have to note that prior to this case, he had no prior criminal history, but in this case, a jury of his peers in Jackson County did find him guilty of several felonies. I believe the last number was 11 felonies and 7 misdemeanors, or in that realm. So I've had to consider that on behalf of the state's argument as well. I think where counsel for Mr. Wester and I differ is on how we view the status of the law as to the fairly debatable and not frivolous standard. This court would agree that if the court was only considering in how it sentenced this case the racketeering, I do think under the case law that the racketeering charge as it sits is debatable and not frivolous. I would note that that is a lower standard than appellate courts have often gotten onto, or reverse trial courts. Again, that is a debatable and not frivolous, and I cannot say that the racketeering appeal is certainly not frivolous, and I do believe it is debatable, and so I think that prong has been met with respect to the racketeering allegation. I think that the issue, or the fork in the road that the appellate attorney has set forth today in the court right now is the appellate attorney would like the court to go to the next level, which is what would have happened had the court tossed the racketeering charge, and what impact would that would have had on this trial, would the mistrial have been declared, et cetera. And I don't think that that's what the analysis of the court should be at this time. Indeed, we're not here simply on a racketeering charge or a racketeering conviction. We are here on that, but we're also here on 3 findings of guilt with respect to official misconduct on 3 separate incidences, 3 fabricating of evidences based on 3 different incidents, various possession of controlled substance, and false imprisonment claims. So there are a number of other counts that this jury convicted Mr. Wester on that I believe are enough to uphold and deny any sort of appellate bond in this case. The court is making that finding based on the totality of the factors that I've already gone over that are set forth, but also the reading of this court is to the debatable standard as to the racketeering charge and how that would influence the other counts in this case. I don't believe that the other counts, again, there is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 felonies, 1, 2, 3, 4, 5, 6, 7 misdemeanors that he was found guilty of. I don't believe that the appeal issue with respect to the racketeering charge supersedes this court's concerns with respect to the other issues, which are not necessarily being appealed in the same manner that the racketeering is. Obviously, there may be consequences if the appellate court disagrees with this court on the impact if racketeering should have been dismissed with this court. There may be an impact that this court should take into account, but it cannot find that impact at this point in time in the case law that it has reviewed. Thus, I'm going to go ahead and deny the motion for post-trial release at this time. Mr. Wester, you are going to have 30 days to appeal this sentence if you think that it is illegal or improper in this case, sir. If you can't afford an attorney, one will be appointed for you. Apparently you have appellate attorney right now, but that offer is still there irregardless. Mr. Wester, I remand you to the Florida Department of Corrections to serve your sentence. Good luck to you, sir. Thank you, and we're adjourned.